Hi everyone, my name's Josh Lewison and I'm a barrister specialising in private client and insolvency. I'm back on the freezing roof of Radcliffe Chambers to share a seasonal case with you, this time from South Dakota. In cases about dead people, particularly will disputes, it's pretty common to come across Christmas cards. An allegation will be made about the quality of someone's relationship with the deceased, and out comes a collection of years and years worth of Christmas cards. And people must keep whole libraries full of bound volumes of Christmas cards to show that the deceased intended to remember them in the will, for whatever that's worth. But what if the Christmas card is the will? In Zech's estate, a decision of the Supreme Court of South Dakota, that was precisely the question. It all comes about because, in common with many states, South Dakota recognises the concept of a holographic will. As we all know, most jurisdictions require a will to be executed in accordance with certain formalities. So in England and Wales, a will has to be signed by a testator and the signature has to have two witnesses under the Wills Act. But where the law recognises a holographic will, it's usually enough that the testator has written it and signed it, even with no witnesses. So in my other jurisdiction, California, it's enough if the signature and the material provisions of the will are in the handwriting of the testator. So back to South Dakota and Dorothy Zech. Dorothy had a niece called Nellie and a nephew called Charlie. And in July 1943, Dorothy made a formal will which made some small gifts and left the residue of her estate to Nellie. In December 1943, she sent a Christmas card to Charlie's wife, Mary. Now, I've made a mock-up of it based on a description in the judgment. And on the front page was a picture and the word greetings. On the second page was a verse from a poem. On the third page was a greeting which Dorothy had signed, and on the back there was a note which said, in part, "I want you to know Herman's farm will be yours when I die. The papers are all made out so you won't have to pay any tax, etc. I've changed some of my plans, so don't say anything." Now, although these were pages, the card was actually made from a single sheet of paper and then folded over. So all of the bits of it were on a single page. Could it be enough to make a testamentary gift of Herman's farm to Charlie and Mary? After all, here we have the signature, and here we have the gift of the farm. The Supreme Court decided not. The judgment was given by Judge Rudolph, believe it or not, who found that there was an insufficient expression of testamentary intent. In addition, Dorothy had already made the formal will, which suggested that she knew how to make a will and was not averse to doing so. Instead, the facts pointed towards an intention to make a lifetime transfer of the farm, but for whatever reason, Dorothy never got round to doing that before she died in the year after she sent the Christmas card. But although the claim failed on the facts, it's clear that there was nothing wrong with it as a matter of law. So if you're sending Christmas cards in a holographic will jurisdiction, it's perfectly possible for a Christmas card to stand as your will. So with that cheery thought, I wish you a Merry Christmas and thank you for watching.